welcome everyone to this installment of the Power Pride Lunch Series. My name is Matthew Goodwin, and I am one of the presenters today. I'm also a member of the LGBT Bar of New York's Matrimonial and Family Law Committee, as is Brian Esser, one of our presenters. On the Zoom with us is Teresa Calabrese, who is one of the co-chairs of our committee, and also then, of course, Joe Williams, who is one of our presenters. I'll go ahead and just do a short introduction of each of the presenters before we get started. So Brian is a solo practitioner in Brooklyn who practices, though, throughout many boroughs and focuses on building families through adoption, surrogacy, and assisted reproductive technology. He represents families in sperm, egg, and embryo donor arrangements and surrogacy. He regularly works with clients pursuing private placement adoption, as well as families securing the parental rights of a non-biological parent through a second parent adoption. Joseph Williams. Joe is an attorney with the Albany law firm Copps DePaula Silverman. Joe practices primarily in the fields of matrimonial, family, and adoption law, as well as the related area of assisted reproduction technology law, including egg, sperm, embryo donation, and gestational surrogacy. Joe is also the co-founder of the surrogacy matching agency, New York Surrogacy Center. New York Surrogacy Center was officially founded in 2020 following the passage of the Child Parent Security Act, what we're going to abbreviate throughout today as the CPSA, and was the first surrogacy agency to be licensed to operate in New York by the New York State Department of Health. Joe serves as the Director of Surrogate Services for NYSC, working with surrogates and intended parents to match them and help them through every stage of their surrogacy journey. And as I said, I am Matthew Goodwin. I am a partner here at Brady Klein Weissman. My practice primarily to date has focused actually on litigation, so matrimonial, family law, divorces, custody, support issues, etc. But with the passage of the CPSA, I, like a number of practitioners, am starting to dip my toes into the area of assisted reproduction technology law and surrogacy, obtaining orders of parentage in surrogacy matters for folks, as well as orders of parentage in ART cases. And I've also worked on a number of second parent adoptions prior to the enactment of the CPSA and also since. So with that, I think we will just go ahead and get started, and I will kick off our slideshow. We're going to take you through a number of topic areas in this PowerPoint, in this presentation, and then we're going to leave it open to questions at the end for about 10 minutes or so. So with no further ado, I will get us started. So the CPSA was enacted passed into law in 2020, but it went into effect in February of 2021. Again, CPSA stands for the Child Parent Security Act. And as is relevant today to today's presentation, New York had, up until this point, starting in the late 80s, banned all forms of surrogacy, both traditional surrogacy and gestational surrogacy. So the difference there, for those who may not know, is traditional surrogacy and traditional surrogacy arrangements are where an individual or a couple will contract with a woman to carry to term a pregnancy, but that pregnancy is born out of the sperm of one of the intended parents and the surrogate's own gametes or her own eggs. And that and then gestational surrogacy is by contrast where there is an egg donor, and the egg donor the egg is fertilized with the sperm of one of the intended parents usually, and then an embryo is created, and through IVF, that embryo is implanted in the womb of the gestational surrogate. So that is gestational surrogacy. The issue in this case, it was a very famous case, In Re Baby M, in 1987 and 1988, was around traditional surrogacy. And this case is really where New York's ban on surrogacy originated and persisted until the passage of the CPSA in 2020. In a nutshell, in that case, the intended parents, a couple, Bill Stern and Elizabeth Stern, entered into a traditional surrogacy contract with a woman, Mary Beth Whitehead. And of course, traditional surrogacy arrangement was that Mary Beth Whitehead, it was her own egg, and she carried to term a pregnancy that was born out of, using Mr. Stern's sperm to fertilize her egg. And through a number of twists and turns, she would not relinquish custody of the baby after the birth of the baby, and actually absconded with the baby across state lines. I think was eventually apprehended in New Jersey, but it doesn't really matter. That's why this tri-state area for years and years banned surrogacy, and New Jersey and Connecticut actually allowed gestational surrogacy prior to New York. We were sort of the last holdout because, as I understood it, we always had a split legislature. So we had a Republican-controlled state Senate and a Democratic-controlled House and a Democratic governor, and it made passage of any sort of gestational surrogacy legislation legalizing gestational surrogacy very difficult. At least that was one of the reasons. So in 2020, Governor Cuomo at the time, there was this Love Makes a Family campaign, and that was actually what led to the passage of the CPSA. But bills were introduced as early as into the New York State Legislature trying to legalize gestational surrogacy as early as 2013. So for our purposes in this presentation, the CPSA, this legislation, it creates a path to establish parentage when one individual is not a biological parent, whether born via natural birth, assisted reproduction technology, or surrogacy. The CPSA legalizes gestational surrogacy and furnishes the requirements for gestational surrogacy agreements, including the Surrogate's Bill of Rights, which is unique in all the jurisdictions across the country that allow for contractual surrogacy agreements. We are the only state that has a Surrogate's Bill of Rights, and we'll talk a little bit more about that later. The CPSA creates safeguards for intended parents and surrogates through regulation of the surrogacy industry. And again, that regulation and that level of regulation is unique to New York as a jurisdiction. And it leaves intact, however, the prohibition against traditional surrogacy. So throughout New York still, parents cannot enter into any sort of surrogacy agreement which provides for anything other than gestational surrogacy. So in other words, there always has to be a donor egg in these cases, and it can never be the case that the surrogate is using her own egg. If that's the basis of the contract, it's unenforceable. So today's presentation focuses on a surrogacy journey for gay families under the CPSA, and I think that's all I have to say on the background and the enactment of the CPSA. So I'm going to pass the baton now over to Joe.
Great, thanks, Matt. So there's the passage of the CPSA was a big deal in New York because for a long time, gay families, but families in general that wanted to pursue surrogacy couldn't in New York unless unless they went out of state. So it's a big shift in the law, and so surrogacy has become much more commonplace over the last year or so in New York. And there's a lot of really positive things about the law in New York. So we're going to touch on a couple of sort of the big advantages to New Yorkers and why it's now a lot easier for New York families to pursue surrogacy. First and foremost is we now have legislation, right? So there was previously, not only did we not have legislation, but we actually had legislation that banned surrogacy. States typically fall into a couple different categories. Some states have surrogacy legislation that sets forth, how surrogacy works in this state. Some states, like New York, prohibited surrogacy, and then some states just don't have any surrogacy laws at all. So, there's nothing which sort of outlines how the process works. Nothing prohibits it, but there's no specific set of laws. So now in New York, we have laws, and we have good laws that set forth what the process is going to look like in order to confirm parentage through surrogacy. So that's a big plus. Matt mentioned the Surrogate's Bill of Rights. Brian's going to talk about that a little bit later when we talk about the contract phase, but essentially the Surrogate's Bill of Rights, it ensures certain protections to surrogates. It was meant to be something that provided protections for women in New York who are pursuing surrogacy as surrogates. What it really does is that it just confirms and ensures that surrogacy arrangements in New York are going to be handled ethically. It sort of takes the best practices for surrogacy arrangements that, agencies across the country should be following and makes them mandatory in New York. There's also, Matt mentioned this too, regulation of surrogacy agencies in New York. I'm going to talk to you guys about surrogacy agencies in a little while and some of the requirements and the role of a surrogacy agency. But one thing that's unique about New York is we are the only state that requires surrogacy agencies to be licensed by the Department of Health. So everywhere else in the country, if you work with a surrogacy agency, there's no oversight authority who is monitoring agencies, who is making sure that they're complying with best practices and procedures. Agencies can open and operate a business without any sort of licensing or oversight requirements. That's different in New York. And if I was an intended parent pursuing surrogacy, I would find some comfort in knowing that the agency that I'm working with has is required to abide by a certain set of best practices in order to become and continue to be licensed. One of the other pros of surrogacy in New York under the CPSA has to deal with insurance. One of the things that we'll talk about as part of a surrogacy journey is, how is the surrogate's health insurance going to be provided for? Whose insurance is going to cover the costs of pregnancy, delivery, those types of things. In New York, one of the benefits of this new surrogacy regime is that there was a mandate put out by former Governor Cuomo's office regarding insurance that requires that, for the most part, insurance providers in New York have to cover surrogacy the same way they would cover any other pregnancy. So as a result of that, most surrogates in New York who have insurance have surrogacy-friendly insurance. Sorry. So the other thing, for purposes of this presentation in particular, as we're talking about, surrogacy as it relates to gay families, New York, by and large, is a very LGBTQ-friendly jurisdiction in a lot of ways, and surrogacy is no exception. The statute is totally gender neutral. The laws regarding parentage and who can be a parent are equally applicable regardless of the composition of the families, same-sex families, opposite-sex families. There's no sort of delineation whatsoever. There are some states who have outdated surrogacy laws who only allow parents to be listed on a child's birth certificate if there's a mother and a father, or if they're married, or various sorts of different requirements across the country. But you're not going to see any of that in New York. The new law is very LGBTQ friendly with respect to who can be a parent and what the process looks like. And the other thing to touch on is, the other big benefit of New York is, everyone is sort of thinking about and worrying about what's going to happen at the Supreme Court. Is Roe versus Wade going to be overturned? What is that going to mean? And in the surrogacy world, what is that going to mean? And what impact is that going to have on surrogacy arrangements? If you're going through the surrogacy process and, is that, what is the effect of that going to be on the ability to terminate a pregnancy, depending on the circumstances during a surrogacy journey? one of the other positives about being in New York is that we don't so much have to worry about that, right? There was in 2019, New York passed a law essentially codifying Roe versus Wade and ensuring that, New Yorkers have access to abortion and abortion-related care. So that's not something that's going to go away in New York. It is a consideration that we're going to have to talk about if we're working with, a surrogate in a different state, and how we're going to have to sort of navigate that, which we'll touch on a little bit later in the presentation. But that's another sort of positive about surrogacy in New York. And then in the interest of sort of playing both sides of devil's advocate, so to speak, there's a couple things about New York that you want to consider as you're pursuing a surrogacy journey here. One being, we won't go into too much of the detail of what the statute says, but one of the requirements of the statute in New York is that intended parents have to provide health insurance coverage for their surrogate throughout the duration of the pregnancy, which is standard, but also for a period of 12 months after the baby's born, which is not standard across the country. That's a longer requirement than we'll see in most states. Most states don't have a requirement at all, and so it's typically something that's left up to the individual contracts. But that's a long time, and the purpose of that in the legislation was to be very surrogate protective and make sure that they had coverage for any complications that may come up after the baby is born. But that's something that is a consideration, especially when you're talking about cost and budget and those types of things. Luckily, like we talked about a minute ago, because of the insurance mandate, most surrogacy or most insurance policies in New York are surrogacy friendly, which helps reduce that cost, but it is something to be aware of. And the other thing is just the novelty of the law, right? In the grand scheme of law, something that was passed in 2020 and went into effect in 2021 is brand new. So there are some judges, many judges, who have never seen a petition for parentage, who have never seen a surrogacy agreement before. Knock on wood, over the last year and a half or so that this has been in effect, we've had really good success as practitioners in getting parentage orders and not getting a lot of pushback from the courts, and they seem to be going relatively smoothly. But this is relatively new, particularly to the courts, because this whole statutory scheme is just brand new to New York. So there's always going to be a little bit of growing pains with any sort of new legislation. Okay, go ahead. So I want to talk, separately from, the law. We've covered a little bit of the law stuff. I want to talk about some practical considerations, things that intended parents need to think about when they are contemplating a surrogacy journey. So I'm going to cover some of the topics that I discussed with couples or single intended parents during an initial consultation when they come in to sort of learn about the surrogacy process. And the point of this is not necessarily to answer every question that you have, but to sort of identify some issues. And it may sort of lead to more questions than answers, but it's good to start, thinking about, some of the areas that need to be considered when you're contemplating pursuing surrogacy. So the first thing is embryo creation. If you don't already have embryos created as an intended parent, that's a first step that you'll need to look into. As you probably will know, in surrogacy, and Matt alluded to some of this earlier, the pregnancy itself is achieved through an embryo transfer. An embryo is implanted into the uterus of a surrogate to hopefully result in a pregnancy. So the first step of that process is creating those embryos. For gay men in particular, that typically means finding an egg donor to create their embryos. So there's various options with respect to, anonymous donor eggs using an egg bank, where you would purchase frozen eggs. There's egg donation through an egg donor where you undergo a retrieval procedure. There's known egg donation if you have a friend or a sister or someone who is willing to be a donor for you. So, whatever method you choose, the first step would be researching the various options in egg donation, looking into egg banks online, talking to your fertility clinic if you have one about whether they have an egg donor program, talking to an egg donation agency, just sort of looking into your options with respect to egg donation so that you can then take that next step of creating your embryos. Because the sperm is the easy part, right? Like the egg donation is typically the much more difficult and expensive part of that process. The other alternative is embryo donation, where if a family has embryos that they created for their own, parentage journey, and they have embryos left over after they've completed building their family, sometimes they'll donate those embryos to other families or to clinics. So that's an option as well as a means of obtaining embryos. It's often less expensive to pursue donor embryos, but there's no guarantee about, the availability and how easily you'll be able to locate those, as well as the inability to have a biological connection to the child, if that's something that's important to you. So, a first thing to consider as you're going through the process of surrogacy is, do I have embryos? If not, getting started on the process of creating them, because that can sometimes take a while, depending on which path you pursue. The second thing is a fertility clinic. So if you don't already have a fertility clinic or a fertility doctor, you need to find one. The fertility clinic is where your embryos will be created, where your embryos will be stored, where your surrogate will be medically screened when it comes time to start the surrogacy process, where the embryo transfer will happen. So that's an important part of the process. And if you're working with an attorney or an agency, they can certainly help provide you with referrals to a clinic. You can also look on the Department of Health website for clinics that are assisted reproduction service providers that are registered with the Department of Health. But finding a clinic that's going to be able to sort of walk you through the medical aspects of this process is going to be an important thing as well to start early in the process. You'll also need an attorney. And at this point, when I'm meeting with clients through my agency for the first time, I will refer them to someone like Brian or Matt to walk them through the legal aspects of surrogacy. If you're pursuing surrogacy in New York, you have to be working with a New York licensed attorney. And I would always strongly recommend working with an attorney who is versed in surrogacy and assisted reproduction law specifically. It's a very sort of niche area of the law. It's highly specialized. You're not going to want to work with a general practitioner or even a general family law practitioner, because doing divorces and custody cases is extraordinarily different than doing a surrogacy case. And as you could probably tell from some of the slides that Matt was going through, some of the details about the statute, it's complicated. And so you want to make sure that you're working with someone who is really specialized in this area of the law. And then the other piece will be locating an agency. So if you're using an agency to find your surrogate, to match you with the surrogate and to assist you with the journey, you're going to want to locate an agency. In the interest of full disclosure, we're talking today about agencies and the agency involvement in the process. You don't have to use an agency for a surrogacy journey. Independent journeys are an option. In an independent journey, you sort of do it all yourself, right? So like you find your own surrogate, you screen your own surrogate, you coordinate your own medical and psychological screenings. All the various pieces of the process are the responsibility of the intended parent with the assistance of your surrogacy attorney. So, we're not going to focus on that today, but just be aware that that is an option. We're going to talk about some of the benefits of using an agency and why people do use agencies, but you don't have to. So I run a surrogacy agency, New York Surrogacy Center. So a lot of the agency process that I'll talk about is, sort of how my agency does things, with the understanding that there will be some variation from agency to agency, but generally, we'll talk about that process. And then, once you've got your attorney and your clinic and your agency and all those types of things, it's time to start thinking about, what is the surrogacy journey going to look like for you? What are you looking for in a surrogate? Do you want to match with a surrogate in New York so you can have, a local match? Would you prefer to match with someone in a different state? If they live in a different state, what is the travel expenses going to look like? What are the laws in the state that the surrogate lives in? Do they have surrogacy friendly laws? Are there surrogacy friendly laws LGBTQ friendly specifically? Because that can vary to some extent. Does the surrogate have health insurance? If she does, what's the cost of her health insurance? A lot of different considerations. We alluded to Roe earlier. What is her position on abortion? What is her position on terminating a pregnancy, and under what circumstances would that be something she's comfortable with? What's your position on that issue, right? Does she live in a state that has, a law poised to go into effect if Roe is overturned, and what is that going to mean? What type of relationship do you want to have with her? Do you want to be friends on Facebook and text and FaceTime with her frequently, or do you want to have more of a business-like relationship with your surrogate? So there's no right or wrong answers to any of these questions, but these are things that you'll need to start considering as you're contemplating a surrogacy journey, because, when it comes time to looking for the right surrogate for you, you want to be prepared to answer, how do I feel about these issues? What do I want my surrogate to feel about these issues, so that your agency can help you find an appropriate match? And then the final consideration that I'll touch on briefly is the cost. That's the biggest question that I get from intended parents is, what is this going to cost? And it's not cheap. Unfortunately, I wish I had a better answer to this question. And it varies, right? There's a huge range of costs depending on the circumstances. There's a lot of variables. The surrogate's base compensation varies. I think Brian will touch on this at some point, but the compensation varies a lot. Like, I see compensation from $35,000 up to $70,000. So there's a lot of different things that go into that. What type of insurance does she have? How much is her insurance? Do you need to purchase an additional insurance policy for her? Is she a stay-at-home mom, or is she a nurse that makes $30 an hour? And how much, if she's going to be on bed rest for a month, how much is that going to cost in lost wages for you? So there's a lot of variables that can go into it. Generally, and this is a very generally, I tell intended parents to typically budget between $100,000 and $175,000 for a surrogacy journey, including, their fertility clinic fees, their agency fees, their base compensation, insurance, legal fees, et cetera, et cetera. So, talking about sort of, budgeting and what that's going to look like and where the funds are going to come from and all of that is certainly a conversation that we would have very early on. So then
I'll jump in real quick. There's a question in the chat, and so any of us can take it. But so the question is: is using a sibling or other relative as a surrogate? If I guess if that's your plan, if that's the person who's agreed to be a surrogate for you, in that context, is using the surrogate's own eggs, if the surrogate is the genetic parent of the child, is that still off the table in New York? So Matt, do you want to take that question?
The answer is unequivocally yes. It's right in the outset of the statute, and it says, eligibility to enter into a surrogacy agreement. It's Family Court Act 581-402. And it's subsection 3. The person acting as surrogate must not have provided the egg used to conceive the resulting child. So as far as the woman's egg being her own, that is most certainly prohibited. It is silent, and if I'm understanding the question in the chat, it seems to be asking, well, could a woman, like, if I'm understanding it, it's could my sister be the surrogate if the egg was not her own? And I think the answer is yes, she could. There's nothing that prohibits that in the statute. Of course, I probably would have a lot of questions for my client and want to talk that through with them ahead of time, because there's just clearly going to be a lot of intra-family dynamics. One of the pieces of this statute, and we'll get into it later on with orders of parentage, is that you're essentially, many people are, often I think, and Joe, you would know more about this and be able to speak more about this, I think that people have very good relationships often with attendant parents, have very great relationships with their surrogate, and it's not, though there's an arm's length contract that created this relationship, I think they become very close, et cetera. But at the end of the day, that surrogate is not a parent and does not have parental rights. And so, if you're asking your sister as an intended parent to be your gestational surrogate, that's a person who's going to you may have a lot less choice about whether or not that person remains in your life and in the life of the child than you would if it's a surrogate who you find through a matching agency.
And on the question of her own eggs, so yes, under the statute, you wouldn't be able to obtain a parentage order under the CPSA if your surrogate's own eggs were being used. That would be traditional surrogacy, regardless of whether they're related to you. However, it's not illegal like it used to be in New York. The contract is just unenforceable. So if there was a dispute or an issue, or you went to court to try and enforce the agreement and get a parentage order, you wouldn't be able to do that because it's an unenforceable contract. You know, there's not going to be any sort of penalties. In the old days, I say the old days, 2 years ago, there would be potentially penalties associated with that if there was compensation involved.
Criminal penalties.
But, right.
Well,
the way, you know, the result in this case, if you were to pursue an arrangement like this, where your sister was your surrogate and her own eggs were being used, at the end of the day, she would be legally the mother of that child, and you would have to adopt the child in order to establish parental rights. So is it possible? Yes, but not possible under the CPSA, and it's an unenforceable arrangement.
actually, the CPSA didn't repeal the possible criminal penalties on genetic surrogacy, which is what the statute changed the name to. So so like I think there's like a $500 civil penalty for the intended parents and the surrogate if you enter into a traditional or genetic surrogacy arrangement that violates the statute. And yeah, for compensation. But then there's the possibility for, you know, for doctors and lawyers who participate in these arrangements on, you know, second offenses and things like that, for it to be some sort of low-level felony with penalties of up to $100,000 and things like that. So, I mean, you know, nobody is likely to go to jail, but you know, but there are disincentives for, you know, for attorneys and doctors to participate in these arrangements.
We're doing very well on our agenda and our itinerary. So, you know, before we move on, Joe, to you talking about the agencies, if we back up a little bit to the discussion of New York versus other surrogacy jurisdictions, because I know this, as you know, from our planning in this, for this CLE, talk a little bit, if you can, about how does your agency handle jurisdictions? Will your agency match with surrogates who are in jurisdictions that, for Texas, for example, where they've all but outlawed abortion essentially at this point, or in jurisdictions where they have the trigger laws that are set to go into effect? How is your agency handling that issue?
So there's a distinction between how we're handling things in Texas versus other states, because the current law in Texas not only prohibits the abortion, but it also provides for a civil cause of action where a private citizen can sue anyone who participated in the surrogacy arrangement. So our reading of that law
in the abortion, right? In the abortion.
I'm sorry, in the abortion. Yes. Thank you for clarifying. Yeah, big difference. Yes. So our reading of that would be, you know, if we were involved in a surrogacy arrangement with a Texas surrogate, for example, and the contract provided for abortion under certain circumstances, you know, and the intended parents wanted to exercise that, and the surrogate was in agreement with that, you know, not only is that prohibited by the state law where the surrogate resides, but it also potentially subjects the agency, the attorneys, the doctors, anyone involved in that process to liability for a lawsuit. So we are not currently working with surrogates in Texas as a result of that. Some agencies are, many agencies are, and it's just something that, as intended parents, if you're presented with a potential surrogate in Texas as a match, something to consider and talk to your lawyer about. With respect to the other states, as far as I'm aware, none of the other states that have these trigger laws none of those laws also include you can be sued if you assist in the process type of a clause. They're just bans on surrogacy after a certain period of time, or outright bans on surrogacy. The workaround for that, in my opinion, was if you're in, and I'm just going to make up a state, if you're in Mississippi and you have a a law that says, no termination after week, whatever, and you want to exercise, you want to terminate a pregnancy and the surrogate is in agreement with that, the workaround from my perspective would be the surrogate then has to leave the state to go to a jurisdiction where that is permissible. And so at this point, that's still an option, right? Like it is still an option, even if Mississippi says you can't get an abortion here, that a surrogate can come to New York or go to a neighboring state that has less, less onerous laws on that issue and still be able to do that. Texas is a little bit of a different scenario. So we'll see, and we'll see what these laws look like if they get passed and what types of restrictions they have. But that's typically the workaround that we would imagine.
And I guess we should back up just for folks' edification that this becomes an issue because for a surrogacy agreement to be enforceable under the CPSA, it has to be the case that the surrogate has decision-making control over the pregnancy from start to finish. So it's always up to the surrogate in New York or a surrogate who is party to a New York surrogacy contract. It's always got to be up to her whether or not to terminate the pregnancy, right?
Right. And I mean, I feel that would really, from a statutory standpoint, yes, that's certainly true in New York. From a constitutional standpoint, at least at this point in time, she would have that right regardless of where she was.
Right.
But yeah, it's codified in the statute in New York. And
so, Brian, I'm going to pose a question to you because I know you and I have discussed some cases where for example, an intended parent, I don't know if their choice was New York versus an international jurisdiction. I know, for example, Mexico is a popular destination for international surrogacy. So, we talked a little bit about it being pretty expensive here in New York.
Right.
If somebody comes to you, an intended parent, and they're thinking about setting out on this process, how do you talk to them about New York versus, for example, an international jurisdiction where you might be able to enter into a surrogacy arrangement, but there might be some risks associated with it?
Yeah. I mean, if you're looking at surrogacy internationally, I mean, the landscape becomes a lot more interesting really quickly. I mean, in some countries like Mexico, the best you're going to get is a birth certificate listing the surrogate as the mother and the genetic father as the father of the child. And so then you're looking at having to complete a second parent adoption. Here in New York, there's possibly some latitude to use the CPSA and obtain a judgment of parentage, but that has some other kind of downstream effects that might not be as beneficial. Like you wouldn't be able to get a certificate of birth data after a parentage order. So that's a consideration. You also have to consider your own citizenship. So you need to make sure that you can obtain legal status for the child in the United States. Most commonly, we would do that by getting a consular report of birth abroad. So a declaration that the child is a U.S. citizen at birth based on a genetic connection to a person who's a U.S. citizen. So then you have to look at, what are the citizenship, what's the citizenship of the intended parents? And also, do they meet the other requirements? Because just being a U.S. citizen isn't enough. You also have to, meet certain residency requirements. So that's a factor. Certainly Mexico is a country that I see a lot. I've also consulted with, families who are considering, Colombia, the Republic of Georgia, Kenya. I had a family that had a child in Kenya. In some of the countries that used to be very popular for international surrogacy, like India, Thailand, and Nepal, they have closed their I mean, not programs, but they've made it, impossible or illegal for, for international intended parents to have children through surrogacy in those countries. So there's a lot that you need to kind of, look at, and it's really important to, understand what the legal regime is in the country where you're looking to go. And, it's frankly a little bit difficult to generalize. So, and often I make referrals to attorneys in those countries so that, intended parents can get legal advice about, about options, and, what the end result is going to be, in terms of, obtaining a court order or a birth certificate.
So we have another question in the chat here from that asks, does the concept of compassionate surrogacy exist in New York? So Joe, do you want to take that one?
Sure. And yes, it absolutely does. So compassionate surrogacy is, sometimes called altruistic surrogacy. It's essentially surrogacy where your surrogate is not being compensated. So the scenario that typically comes up would be if you had a family member, friend, et cetera, who was willing to carry for you without being compensated. And yes, that's absolutely permissible. It's, if you're lucky enough to have someone in your life who's willing to do that, that's certainly a huge cost savings for you. And it's also something that's certainly enforceable. There's no distinction in the statute between compassionate cases versus compensated cases, except that there are certain, there's a couple of differences, with respect to the financial arrangement. If you are working with a surrogate that you are compensating, you're also required to pay for her health insurance, her life insurance, her attorney's fees, those types of things. Whereas if it's a compassionate arrangement, those things are not mandatory. It's optional whether she wants you to pay for her health insurance, life insurance, attorney's fees. Oftentimes intended parents still do pay for those things, but it's not required in a compassionate case like it is in a compensated case. So there is some slight differences with respect to what's required to be paid for, but yeah, it's totally something that is envisioned by the statute and happens in New York.
Great. Okay, do you want to go on to talking about agencies, Joe?
Sure. All right, so the next thing I want to chat with you guys about is the surrogacy agency and the role of a surrogacy agency, and why, if you are pursuing surrogacy, you might want to consider using an agency. So all of the considerations that, we've sort of been touching on throughout this presentation, things like, what state's law do you want to follow? What's your surrogate stance on things like termination? What's your surrogate stance on vaccination, right? Does she have a COVID vaccine? Is she going to get boosters during the pregnancy? All sorts of, these considerations of things that you need to think about when you are starting a surrogacy journey. That's what your agency is there to help you with. There's a lot that goes into this process: medical, psychological, insurance, legal. And the role of the surrogacy agency is to make sure that they're helping you navigate that process so that it's not all on you, to make sure that everything goes correctly. The reason that's so important is because, one of the requirements of the New York law is that under the CPSA, if you follow all of the steps correctly, right? If you do all the things you're supposed to do, your surrogacy agreement is compliant with the law, your surrogate meets all the necessary eligibility criteria, then the court has to declare you the legal parents of your child. There's not really any discretion there for the court to deny a parentage petition unless you've not followed the law and not done something according to the statute. So having a surrogacy attorney who's versed in the CPSA and having a surrogacy agency who's familiar with the process helps you to avoid the possibility of messing something up along the way that could potentially impact the result of being established as the legal parents. So the agency, in my view, kind of has three main roles: education, screening, and sort of facilitating the journey. So as far as education goes, it's educating the intended parents and the surrogates about the whole process. What is this going to look like? What can you expect? What is the process going to entail from beginning to end? To get you thinking about some of these issues that we've raised today, to sort of help you sort of think about, what type of a surrogate might be a good fit for me? What am I looking for in a candidate? Thinking about, cost and budgeting and all those types of considerations. And the agency also educates surrogates too, right? So that's also, we're working with surrogates at the same time to make sure that they understand the process. Because from an intended parent perspective, you want a surrogate who is educated about the process. You want a surrogate who knows what to expect, knows what is expected of her, and is coming into this process with everyone being fully aware of, all of the details, full transparency being very important. So, the agency has a dual role with education, making sure that everybody understands what's going on. The second role would be a screening role, primarily for screening surrogates to make sure that they're a good candidate for surrogacy, because not everyone is. Does the surrogate have any criminal history? Does she have any CPS history? Does she have any history of drug use? Does she have any STDs or STIs that would potentially impact the safety of a pregnancy or delivery? What is her pregnancy history like? Has she had healthy, uncomplicated pregnancies herself? Has she talked to her doctor about becoming pregnant again? What does her doctor think? Does she have adequate support from her family and friends? Does she have a stable home life? Does she have any sort of medical history or medical issues, mental health history or mental health issues that might impact her ability to successfully be a surrogate? So the agency is screening potential surrogates for all of those things before the matching process. So, we're not theoretically, you're not going to be presented as a candidate for surrogacy who hasn't been screened. So you're knowing that, she's a good candidate, because she knows about the process. She's been educated by the agency, so she knows what to expect, and she's been vetted. And you'll talk to your agency about, your matching preferences. So where she lives, how old she is, what her medical history is like, any particular, whether she's vaccinated, what are your thoughts on vaccinations, her thoughts on vaccinations, all those types of topics to make sure that you guys are a good fit. Your agency is going to match you based on the criteria that you're looking for. And so that's one of the main roles as well, is making sure that they're finding you, a surrogate is a good fit for you and your family. And then the agency is responsible for facilitating the journey. So making sure that if you need an egg donor, they're helping you with resources for egg donation, embryo donation. If you need a clinic, they're helping, connect you with a clinic that's a good fit for you, referring you to an attorney if you need to talk with a lawyer, making sure that they are helping you get all the necessary insurance policies in place, making sure that the surrogate's medical appointments get made and that she gets to all of her appointments on time and that the results are sent back to the clinic, and facilitating with the lawyers to make sure that the parentage proceeding is filed and that everything's okay with the birth certificate, and making sure that the hospital knows this is a surrogacy pregnancy. So the intended parents are going to be there, and make sure you have a room and she has a room, and everybody understands that you guys are the ones that are going to be the parents making the decisions for the baby when they're born. So, just sort of guiding everyone throughout the process is one of the main roles of the agency, really from beginning to end. And then as far as the Department of Health, we talked about this, we touched on it already, so I won't spend much time on it, but agencies have to be licensed. And so agencies in New York have to be licensed, nowhere else, but in New York, agencies have to be licensed. So there's regulations and there's guidance materials that New York State and the Department of Health have put out about, how agencies are supposed to operate. So, you're working with a licensed agency means that your agency is sort of following these best practices as articulated by New York State, making sure that all of these pieces are being covered. And then and there's agency fees, right? So there's a fee that you'll pay to your agency in order for them to do all of this stuff for you. And certainly that is a lot of times people think about pursuing a surrogacy arrangement independently rather than working with an agency, so that there's not an agency fee that they pay, with the understanding that the reason you're paying those agency fees is that everything then becomes on you, right? Making sure that you have life insurance for your surrogate, health insurance for your surrogate, disability insurance for your surrogate. You do all of the coordination of the medical appointments. You make sure that she has a monitoring clinic that can do the sonogram that she needs to have done at week 12, whatever it is, that all the things that go into a successful surrogacy journey, those are the types of things that the agency is doing, which is what your agency fee is going to cover. And every agency is slightly different. I typically see agency fees around $20,000 to $30,000. Depending on the agency that you're working with. But, and then as far as selecting the right agency, I think it's just a matter of, you got to do your research. A good place to start if you're in New York is the Department of Health website, because agencies are required to be licensed in New York. There's only a handful. There's probably, I think last time I checked, there were about 12 or 13 agencies in New York that were licensed by the Department of Health. So it's not a huge list. But that's a good place to start and sort of figure out, what their agency is all about. Are they an LGBTQ friendly agency? Most are. What are their matching times? What are their waiting lists like? What are the costs? How do they structure their program? How do they do their matching? Those types of things. If you are going to go the agency route, there's a lot of things for you to consider with respect to what the right agency is for you, and a lot of things that the agency will sort of help you facilitate as you move through the process.
Okay, thank you. I'm going to turn it over to Brian to talk about the agreement.
Great. We could do a whole hour and a half, 2 hours on drafting surrogacy agreements, but I just want to sort of, provide kind of an overview here, because, having an agreement is a key feature of the statute. Basically what you're doing at the end of the process, or actually when you're petitioning for a birth order, is asking the court to ratify, basically the agreement between the intended parents and the surrogate. And so, so it's important to, to talk a little bit about, kind of the elements that go into it. I like to kind of start with sort of like, what's the nature of the agreement, the statute does use the term agreement, as opposed to contract, although we do kind of use the two terms interchangeably. In sort of, preparing for this, I did kind of look up the definitions of agreement and contract. Agreement is, sort of like an agreed upon arrangement, versus a contract, conveys the idea of something that's, legally enforceable. And, while there are, legally enforceable elements to a surrogacy agreement, really, what I think a lot of practitioners in this area will tell you is that, the agreement's supposed to serve as a roadmap. And so, it's intended to document all of the, the screening, how the, who the parents are going to be, the qualifications of the surrogate, genetic relationships, conduct, how the parties plan to interact with each other. But, and there are elements, as well as the financial terms, there are elements that have, sort of contract-like elements, but there's other parts that, if, we're all lawyers, like if you tried to go to court and sue somebody over, did she, did the surrogate, did they, eat sushi at a certain point in time in the pregnancy when they weren't supposed to, you're probably not going to get any financial damages for that, right? So let's move on to the next slide. Sorry, can I do that? Okay. All right. So in terms of drafting the surrogacy agreement, sort of overview of the process, if it's an agency match, I get a referral from the agency with a term sheet, that sort of laying out all of the relevant details. Generally speaking, the intended parents lawyer drafts the agreement. So, I'll put together a draft, review it with my clients. Some clients want to go over it in, really specific detail. Others, it's a much quicker sort of process. Then the intended parents approve the draft. Then I'll send it to the attorney for the surrogate. Their lawyer will review the agreement with both the surrogate and the surrogate spouse or partner. The spouse or partner is always going to be a party to the agreement. If the surrogate has any comments, we'll deal with those. And then finally, there's a final agreement that everybody, signs off on. And then I will send legal clearance to the clinic that's going to do the embryo transfer. And then at that point, they'll start the surrogate on medications, usually a course of medication to prepare, the uterus for the embryo transfer.
Next slide.
Yep, next slide. Okay, so then the CPSA has provides a set of core terms. They're found in section 581-403 that are supposed to be common to all surrogacy agreements that are drafted in New York. And so these agreements, I mean, these basic provisions are things as basic as the idea that the surrogate is going to undergo an embryo transfer and then give birth to a child, that the surrogate and the surrogate spouse or partner is going to surrender custody upon birth, that the surrogate has no legal rights to the child. The intended parents are going to accept custody upon birth and assume responsibility for support of the child. So this is always a provision that I, particularly when I represent surrogates, that I am, laser focused on, that the idea that basically there's no wiggle room for intended parents, that, intended parents can't say, oh, the child's not healthy. Oh, this was a twin pregnancy and I was really only hoping for, one child, or God forbid, there's some sort of complication or, premature delivery, and, intended parents say, no, only healthy babies. I mean, that's just not, that's not part of the arrangement. Like, you don't get to do that. The statute says that intended parents' rights are not assignable. So you can't have an intended parent that is effectively a straw man to then pass on custody of the child to somebody else at some point in time in the future. The intended parents' rights aren't affected by any subsequent divorce or separation of the intended parents. All the parties will cooperate together to establish legal parentage, to petition a court for that pre-birth order. And the intended parents are also going to agree to execute a will prior to the embryo transfer, actually prior to signing the agreement, designating a guardian for child. Move on to the next slide. All right, and so then we've talked a bit about the Surrogate's Bill of Rights. So here's sort of an overview of those substantive provisions. So the surrogate has the right to make all health and welfare decisions for herself regarding the pregnancy. I do just want to make a note on language terminology here. I did use feminine pronouns here, and I probably should have used gender neutral pronouns, which is what the what the statute uses. It's incredibly rare that we work with surrogates who who identify as non-binary. I think there's a handful of examples of trans men and trans masculine folks who have been surrogates, but certainly they could be at different points in time in the future. So my apologies for the oversight on the language here. The surrogate has right to legal counsel of their own choice, paid for by the IPs. They have the right to terminate the surrogacy agreement at any time before a pregnancy. This is actually an interesting feature of the New York statute. So, you could have a situation where surrogate goes through the entire process of screening, signing this agreement, and then at some point in time, before an embryo transfer, decides, what, actually I'm going to back out. I don't want to be a surrogate, for whatever reason. In a lot of other states, the agreement will say, I've had some lawyers, when I've had conversations with this, say, I've actually had some situations where surrogates have backed out, after IPs have spent all this money. And so, because it's expensive to even just get to the point in time where you're doing the embryo transfer. There's a lot of time involved. There's a lot of money involved. And so, there's a sense of, well, maybe there should be some sort of, financial penalty for not even making one attempt. New York doesn't allow that. This is probably one of those areas where, attorneys could, debate back and forth about which is the better approach. But, New York has taken a position, and, we're saying that, the agreement can be terminated at any time. The surrogate has the right to health insurance and as well as life insurance. The statute specifically says $750,000 worth of life insurance. How that number was, agreed upon, completely beyond me. I don't think there's any basis anywhere in the legislative record or in the advocacy for the statute settling on that dollar amount. But that's the number, which is a perfectly fine and adequate number, but it feels a little bit arbitrary. Let's move on. Trying to be mindful of time. Okay, so then the financial terms. I think this is the piece that a lot of people think about, like, oh, when we're drafting a surrogacy agreement, that the financial terms must really be the core of the agreement. To many extents, they're not. I mean, a lot of lawyers put all the compensation terms in an exhibit that sort of accompanies the agreement, and so there's one document that covers all of those other things that we've just talked about. And then there's a separate document that's going to address things like the financial terms. So compensation is permitted under our statute, and the compensation is specifically for medical risks, physical discomfort, and inconvenience, and the responsibilities that they, as the surrogate, are undertaking. Again, here in New York diverges a little bit from some other states, where some states talk about the compensation as actually being pre-birth child support. We've definitely not gone that way, very much trying to avoid any sort of implication of fetal personhood. I think this is a really good sort of encapsulation of the of the purposes of compensation under a surrogacy agreement. If the surrogate and IPs are matched by a matching program, the financial terms are usually agreed upon at the match. So, when intended parents are agreeing to work with a specific surrogate, they know what the financial ask is going to be. And then, the lawyers in drafting the agreement, it's not typically, our role to renegotiate compensation at this stage. So we take the match sheet and, use those terms. But, if parties are matched independently, there often is more negotiation that can take place. And then, as a general principle, a surrogate should not be put at any type of financial disadvantage, due to her participation in, the overall surrogacy arrangement. So, when I'm working on these agreements, if there's any type of, cap on like lost wages or something like that. So like if a surrogate is put on bed rest, I, very much, work to make sure that those caps are eliminated, as well as other types of, financial penalties that, that sometimes people try to put into their agreements. So then, Matt, if I can get you to advance to the next slide. All right. So base compensation, I mean, Joe mentioned already, we can look at, anywhere between $25,000 to $75,000. Typically that base compensation is paid out in monthly installments. If the child is born prematurely, then, there's the possibility that the surrogate won't receive that entire full base compensation, because, the purpose of the compensation is to, reimburse a surrogate for, time spent, gestating and the risks associated with that process. We're not actually paying for a baby, and if compensation is predicated on things like a live birth, then it starts to look a little bit more like, like you're paying, specifically for a baby, and that's not allowed. There'll also be, an increase in that fee if the surrogate is gestating multiples. I had a surrogate who I represented, and she carried twins for a family, and then she was going to be a surrogate again for a second time around, and she said this time she absolutely was not open to carrying twins, that she'd had like 2 or 3 of her own children, and the twin pregnancy was much harder on her. So that's sort of the justification for for the multiples. There's typically a monthly allowance in the agreements that that covers things like local, mileage for going to, prenatal appointments, notarization, over-the-counter medications, things like that. Sometimes there'll be fees for certain events, such as the embryo transfer, to reimburse the surrogate for her time and energy, and respecting the time that's involved in preparing for for an event like that. There'll be fees for invasive procedures such as an amniocentesis or a C-section, and then reimbursements for travel, housekeeping, lost wages, childcare. On travel, it's not uncommon for intended parents to be in one state, a surrogate to be in another state, and then the clinic that they're working with to be in a third state. So you got to get all the parties to the same location for some of these events. So sometimes there can be a fair bit of travel. And then finally, the intended parents will agree to be, financially responsible for, health and life insurance premiums. So then, Matt, let's move on to my last slide, I think. Then in terms of like other, sort of, agreed upon provisions, there'll often be, extensive sections on, the surrogate's agreement to make different types of, lifestyle modifications, like avoiding travel, certainly not using, alcohol, tobacco, cannabis, and other drugs, can include different types of dietary provisions, as well as, avoiding exposure to HIV, Zika, COVID-19, things like that. There'll be confidentiality provisions. These can be heightened, particularly here in New York, where we, get some high profile clients from time to time. The agreement cannot restrict healthcare decisions, which we've, touched on a couple of times. And then, as I said, the agreement shouldn't predicate, compensation on a live birth. I think anticipating that I was a little short on time, I kind of addressed some of that already. So, with that, I will turn it over to you, Matt, for discussion on the judgment of parentage piece.
Great, thank you. So, prior to the enactment of the CPSA, there were plenty of children born pursuant to surrogacy agreements in other jurisdictions where that was enforceable and perfectly legal. And my practice has included, those parents coming back, those intended parents coming back to New York, and they would have both parents on the birth certificate even, but practitioners would, I think, pretty uniformly in New York tell that family, that LGBT family, you're going to be protected, both of you as parents, if there's a second parent adoption for the non-biological parent of the child. So there was no option, which there is now under the CPSA, to get an order declaring parentage through any other means. And just because a parent is on the birth certificate is not actually proof of parentage. It may be an indication of parentage, but it's not conclusive proof of parentage. So we were left counseling clients that for the non-biological parent prior to the CPSA, your only real recourse to establish your parentage, if you didn't get an order of parentage in the jurisdiction where the child was born here in New York, was to go through a second parent adoption. And families found that pretty invasive and often pretty offensive, because they felt, and they were, that they were being held to a different standard than other families. So in many ways, the CPSA can correct for that. We'll still get questions from parents who may have had a child through surrogacy. Is there any reason still to do a second parent adoption versus an order of parentage under the CPSA? And pretty much at this point in our practice here at this firm, we're telling folks only if the second parent adoption only really makes sense if you're going to be doing a lot of traveling internationally with the child. We can get you an order of parentage, but you may nevertheless want that second layer of protection internationally with an adoption that's more universally recognizable in pretty much every jurisdiction that says this person adopted this child, and it's a little bit clearer maybe in international jurisdictions. But otherwise, the CPSA is great because it allows for orders of parentage pre-birth and post-birth for children born pursuant to a surrogacy agreement. So it's governed under Family Court Act 581203, and who may petition the child, who may petition the child, the surrogate, or their spouse. Again, my apologies also on the language issue. I should have been more conscious of that. So the surrogate or their spouse may petition for an order of parentage, social services, or other government agency authorized by law, the representative of deceased, incapacitated, or minor who would have otherwise been entitled to maintain a proceeding. When to petition, it can be anytime after, you can bring one of these petitions anytime after a surrogate agreement is executed. Where do you actually bring the petition? So the statute says that you can bring a petition for an order of parentage pre-birth or post-birth in family, supreme, or surrogate's court in any county where an intended parent resides, where the child was born or resides, or where the surrogate resided after execution of the surrogacy agreement. This piece has been a consideration in the few parentage cases I've handled to date, where because of the pandemic, and is there going to be an in-person appearance required versus a virtual appearance? And we can actually talk about here whether an appearance is required or should be required at all. But to the extent that a court's going to require an appearance while COVID remains a consideration, somebody filing for an order of parentage probably wants to check out among the different counties where they might. Is there going to be an appearance required? And if so, is it in person or is it still going to be virtual? A lot of times, for good reason, all of the parties to one of these agreements would be reluctant to have anyone showing up or someone showing up in person, especially the surrogate. So in mine, I've had two now, both in Nassau County. Although the surrogate lived upstate, my intended parents were in Nassau County, and we made the choice to do it there, partially because I'm closer, but we knew that there was going to be no appearance required, or there was going to only be a virtual appearance required. We could have done it upstate, and upstate, the particular counties that we were looking at didn't require any appearance at all, or we thought they might not, but it was really mostly for geographic reasons and my proximity to the courthouse and ability to handle things that the choice was made to do it in Nassau County. But this brings us to the what do you actually include in one of these petitions? The Office of Court Administration has promulgated forms, and they're going to get the job done. I mean, both of my cases, I have obtained the orders of parentage pre-birth for the intended parents, but some practitioners are making their own forms for a variety of reasons. There are copies of the OCA forms included in the materials that were sent out if you signed up for this and if you're attending this. But you're going to include at the very least a summons, a petition, and the big piece here in the statute is a certification that your surrogacy agreement is compliant with the statute. So the Family Court Act says that your petition, it says where the petition says, it's got to be verified, where the petition that's been verified states that the person acting as surrogate or at least one of the intended parents has been a resident of the state for at least 6 months at the time the surrogacy agreement was executed. There's a certification from the attorney representing the intended parent or parents and the attorney representing the person acting as surrogate that the requirements of Part 4 of this article have been met. And there's a statement from all parties to the surrogacy agreement that they knowingly and voluntarily entered into the surrogacy agreement and that the parties are jointly requesting the judgment of parentage. Then if all of those things are present, the court shall enter an order of parentage. There's a debate about whether we should be having appearances on these cases at all. And I already alluded to it that some counties upstate aren't requiring any appearances. They're just they're just doing this on the papers because there's always got to be a certification by both attorneys for the intended parents and the surrogate that the agreement meets the requirements of the statute. In Nassau County, by contrast, the magistrates, and these are pretty routinely being assigned if you're in family court to support magistrates, the magistrates there did want to have an appearance. And my, general thinking is not to, annoy the person who's making the decisions. So I'm not going to raise a fuss and say we don't have to have an appearance, but technically the statute doesn't require an appearance. The other, this also brings up the other question, which is whether or not to actually include the surrogacy agreement with your petition. I did in both of my cases, but that's technically not a requirement under the statute right now, though there is talk that within the context of the cleanup bill that Joe mentioned earlier, the agreements are going to be required to be submitted to the court as part of the as part of a parentage proceeding seeking an order of parentage. Both of my cases where I submitted the agreement, the magistrates had actually gone pretty carefully through the agreements. But some attorneys, are bristling at that the statute says, I'm supposed to only have to submit a certification that says my agreement complies with the statute, and that should be enough to get an order of parentage. So there is controversy about this question of whether or not an agreement needs to be submitted. And I know other practitioners, I think Joe, you've submitted, you've filed for orders of parentage and not included the agreement, and you've obtained the orders of parentage. And I think Brian, you have as well. So, you can look at it and make the choice for yourself. There's no requirement under the statute right now that the agreement actually be included. The whole idea here behind getting a pre-birth order is that the order, if you look at it in the sample order that we provided you from the OCA in your materials, it lays out that upon birth of the child, the surrogate will transfer the child to the intended parents. The intended parents shall take custody of the child. Then the intended parents are financially responsible for the child immediately upon birth. The surrogate is not responsible for the child financially or otherwise following birth. And it most importantly establishes that the intended parents and not the surrogate are the parents. This then becomes a question I've had in my two cases around what actually happens at the hospital at the time of birth. And for those who may not know, the birth happens. I didn't know this, so I've been learning a lot about this. The birth happens, and then usually a social worker from the hospital comes in, and they have paperwork that has to be filled out that gets transmitted to, if you're outside of the 5 boroughs, the state vital records office. If you're inside the 5 boroughs, to the New York City Department of Health. The social worker takes down the appropriate information, transmits it to vital records for the creation of the birth certificate. The way we understand it to be working at this point with vital records for the state is that they're expecting to see in the paperwork from the hospital the surrogate's name in the first instance, and they do issue they create a birth certificate that doesn't get mailed out, that doesn't get sent out. And after the live birth, the attorneys, usually for the intended parent, goes back to the court that issued the pre-birth order of parentage and gets an amended order that's revised to reflect the birth. And upon receipt of that amended order, vital records then will amend the birth certificate. And that's the birth certificate that actually gets mailed out to the parents, the intended parents. Because of the way the process is working with the state, it's taking quite a long time right now for a birth certificate, I understand, to be issued to intended parents, as long as 6 to 12 months. And it doesn't necessarily take that long for other live births. The one thing that I understand also parents, intended parents and surrogates want to be careful about in this process is that there are certain steps that parents will take upon the birth of their child, such as requesting a social security card. And in my two cases, we're telling the intended parents to hold off on that, just because if the timing isn't quite right on that process, the child could suddenly be tied to the surrogate's social security record instead of the intended result, which is that the child be tied to the intended parent's social security record. So, there are considerations around this that have to be taken into account. But then when it comes to the city, the city, as we understand it, has not actually come up with their preferred process of how this is going to work. So I've not yet handled a parentage proceeding for a child in one of the five boroughs. And so, I don't know how the vital record or the New York City Department of Health is going to handle these things. I don't know if our panelists, Brian or Joe, if you know, but those are roughly the considerations that go on once you actually have a pre-birth order. And then, of course, once you do have, I already mentioned this, but once you've had the birth, you are always going back to the court that issued your pre-birth order. If you got a pre-birth order, and we generally recommend that folks do get a pre-birth order, you're always going back to that court and asking that the order then be amended to reflect the facts on the ground after the birth has actually happened. So I don't know that I have anything else. In fact, I know I don't have anything else on parentage, and we have about 10 minutes left, and we can open up for questions. I see that that there's a question in the chat, and asks, how is the parentage proceeding initiated? Must summons be served, and on whom? So I'll field this. In my two cases, what I did was I drafted the parentage petition as being brought on by all parties to the agreement, both the intended parents and the surrogate. I did create a summons, and the summons listed all parties to the agreement. And I recognized as I was doing this feels a little weird, because who's actually, being summoned if everybody's bringing on the proceeding? But no, in my cases, service was not made. It was all on consent. There was a calendar number issued to me and a date issued to me, and I made sure that all parties to the agreement and their attorneys knew about that date for the appearances that were required by the court. But service wasn't an issue. And I suppose if service became an issue, I'm not quite sure a fact pattern in which service should become an issue. Although I guess it would be that you didn't actually have a conversation among all the different parties to the agreement that you were going to be doing a parentage proceeding. But that seems like it would be pretty rare, and that in that case, one of the parties to the agreement is bringing it on, and then they have to notify the folks who I guess didn't know that it was happening. But I really think something's really gone wrong earlier in the process if everybody didn't understand that we were going to be doing a parentage proceeding.
Yeah, I also typically file them as like joint petitions where everybody is saying that they consent to the relief. I guess the question of service sometimes comes up in assisted reproduction cases. If there's a sperm donor that's being used and you don't have any proof that that person is in fact just a sperm donor, the court can sometimes direct service on a donor. Or, for example, if one of the parties, whether it's the surrogate spouse, one or the other of the intended parents, if for whatever reason they didn't sign a consent and they didn't join in the petition, those would all be individuals who would need to be part of the proceeding, since their consent would be, required. So typically the theory is that these are going to be proceedings that service won't be an issue for, because everyone is mutually joining in the petition. But in the event that something did go wrong, like Matt is saying, or there's a donor who needs to be put on notice, there's specific service provisions in the CPSA which direct the method of service in that case.
Yeah. I mean, interestingly, the statute does say that the surrogate has to sign the parentage petition, but the statute doesn't say that the surrogate spouse or partner needs to be a party to the petition, which is it's a little bit weird, to be perfectly honest. So, I mean, from time to time, it happens that that surrogates and their spouses divorce or separate during a surrogacy. It's not the end of the world. It's not great for anybody, but so I mean, I suppose you could have a situation where maybe the spouse or partner needs to get served,
Right.
And then sometimes you get like there was a reality TV personality, Sherry Shepherd, who, wasn't a genetic parent to, to a child that she and her partner, I don't think they were even married at the time, conceived via surrogacy. And, she wanted to say like, oh, I'm not the genetic mother, so like, I'm out. And, you could imagine that would be a situation where, because she's not voluntarily, under those circumstances, petitioning, that maybe she'd be served with notice. But I agree that generally it's pretty rare.
I'm going to go ahead and announce the code for those who are seeking CLE credit for this, that you're going to include in your affirmation that'll be sent out to you if it hasn't been already. The code is W9, R as in Robert, Y2. Again, the code for CLE credit is W9, RY2. I'm not seeing any other questions. The one thing that just came to mind that I would also mention that is good, I think, useful for practitioners who have a lot of LGBT clients to know is that you can bring, so I had a situation where clients came to me and they had a child under a surrogacy agreement under Illinois law. The surrogate gave birth in Illinois. Illinois is a jurisdiction that wouldn't do a pre-birth order of parentage, putting both parents on. So the parents in that case wanted to know, could they take advantage of the CPSA to get an order of parentage and sidestep the second parent adoption that they otherwise would have had to go through? And the answer was, we couldn't bring a parentage proceeding that's because there has to be an attorney affirmation that says there was a surrogacy agreement that was compliant with the CPSA. That agreement, I reviewed it, it wasn't compliant with the CPSA. It was under Illinois law. Why would it be? But you can, and I know, Brian, you have one of these cases right now where you can bring on a proceeding for parentage and you just tell the court that your agreement isn't compliant, but that this child was born pursuant to a surrogacy agreement. It defaults then to a best interest analysis. Yep. And I guess I sort of shrug like it's no big deal. We actually, I mean, Brian, I know you're waiting for a court appearance on that case. So we actually don't know exactly what the courts are going to do in those cases with a best interest analysis and how onerous or not onerous they might make the process. But you are still able to bring a parentage proceeding. It's just a little murky about and probably judge dependent, judicial officer dependent on what's going to happen in that case if you do that.
Yeah. Yeah, I mean, I worked on a case. We got a parentage order out of the Bronx. It was a case that it was the baby was born pre-CPSA and it was a compensated surrogacy. The surrogate was supposed to give birth in Florida, but then of course the baby came early, and and so then they were kind of stuck. And so so we filed for a parentage judgment for that, and the judge just said, well, they've been she said, well, they've been the parents, and we filed some affidavits sort of explaining why they filed when they did and that kind of stuff. And she said, oh, clearly it's in this child's best interest, and right. And there was no hearing, there was no further analysis, there were no background checks, no home study, anything like that. So it's really it's hard to predict what judges are going to do in in those circumstances. So there's one other question in the chat. If you have a pre-birth order, do the parties need to return to court after the birth? I mean, I suppose technically not. I mean, we had a big conference beginning of last month, like adoption and ART attorneys from around the country. And I was talking to a colleague from Colorado, and she said that it's not their practice in Colorado to ask the court to issue another order, kind of, stating the child's name and date of birth and and things like that, that they just go off of the pre-birth order. It's always been my practice to ask a court for a post-birth order that then reflects the child's name and date of birth and things like that, just so that there's no question in the future. I've also had some people tell me that that for full faith and credit purposes that it's possibly better. I also attended a session at that same conference on full faith and credit. Now I'm not so sure that that's actually like a thing, but it's something that I think a lot of people like and want. So, is it necessary? Probably not, but is it something that I would recommend? I mean, it is my practice, and I will continue to do it until somebody tells me that I can't.
And I do it too. And it's just not a matter of, when you say go return to court, it's typically not actually going to court. It's a matter of letting the court know that the birth occurred and having them issue an amended order. So it's not like an onerous, you have to go back for another appearance type of process, typically.
That's right. And the reason in my case, I have one case right now where we're making sure we do it is, and I think this would be true in a lot of cases, for insurance purposes, that the intended parents to enroll the child after the birth into their insurance, would the insurance company accept only the pre-birth order? So, I don't know. And, Joe and Brian, you probably have more experience with that, but my case, we were always going to go back, but just one more reason that we were going back and always going to get the amended order after the birth was because the child has got to be enrolled on the intended parent's insurance. So, so that's really all the time we have. One of our co-chairs of the Matrimonial Committee put in the chat, and I'll echo her, that all of our attendees should consider joining the Matrimonial and Family Law Committee of the LGBT Bar Association of New York, or just consider joining the LGBT Bar Association of New York, if not the Matrimonial and Family Law Committee. It's a great organization, and we are thrilled to have been able to put this presentation on for you the first month of the first day of Pride, the month of June. And with that, I will go ahead and close it out. Thank you to Brian and to Joe for all of your work on this, and to Teresa for your help and efforts organizing it. And I hope everybody has a great and healthy and safe Pride Month. Thank you.
Thanks, guys.
Thank
Take
you.
care.